Welcome to Equals Among Equals, where we decode Article 14 of the Indian Constitution, the foundation of legal equality. Imagine a wealthy individual and an ordinary citizen standing before a court. Does the law see them differently? Article 14 says no, but the reality is more complex. Article 14 is the bedrock of the Indian Republic, promising fairness, justice, and equality to every citizen. Article 14 is composed of two distinct pillars, equality before law and equal protection of laws. Let's break down these two critical concepts. The concept of equality before law is a negative concept borrowed from the United Kingdom. It mandates that no one is above the ordinary law of the land. In contrast, equal protection of laws is a positive concept inspired by the USA. It demands affirmative action to ensure that equals are treated equally. Let's start with equality before law. This principle ensures the, quote, subjection of all citizens to the ordinary law of the land. It is about the law being supreme. This means whether you are the Prime Minister or a common laborer, you are subject to the same legal standards and jurisdictions. No person enjoys special privilege. This principle is famously associated with the jurist A.V. Dicey's concept of the rule of law, asserting that governmental authority is only legitimately exercised in accordance with laws adopted through an established procedure. Moving to the second pillar, equal protection of laws, this is the dynamic aspect of Article 14 that ensures substantive fairness. Equal protection means like should be treated alike. This recognizes that sometimes unequal situations require different treatment to achieve true equality. Think of it this way: giving an adult and a child the same size chair is uniformity, not fairness. Equal protection means giving them chairs that allow both to see the table. Now, a crucial distinction. Article 14 forbids class legislation, but it permits reasonable classification. What does this mean? Class legislation means creating arbitrary groups to favor or disfavor, which is unconstitutional. Reasonable classification is grouping people based on differences relevant to a legislative goal. The old doctrine used a twofold test for validity. First, intelligible differentia, meaning a clear, discernible difference, and second, rational nexus, meaning a logical connection to the objective of the law. Over time, the Supreme Court shifted its focus to a broader test, known as the new doctrine of non-arbitrariness. The landmark E.P. Royappa case established that equality is a dynamic concept, not a static one. It's not just about equal law, but about fairness in action. The court declared that any state action that is, quote, arbitrary, illogical, whimsical, or unfair is, by definition, a violation of Article 14. Equality and arbitrariness are sworn enemies. Article 14 is not absolute. There are constitutional exceptions to legal equality, such as protections for the president, governors, foreign diplomats, and provisions under Article 31C. These add necessary legal depth. To wrap up, Article 14 stands as our guarantee against tyranny and arbitrary rule. Ultimately, Article 14 ensures we are a, quote, government of laws, not of men, protecting civil liberties and guaranteeing a legal framework of justice. Now, we ask you, in your opinion, is the Indian legal system truly achieving equal protection today? Share your thoughts below, and stay tuned for our next video on Article 15, Prohibition of Discrimination.